Dear Lona, is my husband trying to screw me in a divorce? If you're wondering whether he's trying to screw you in a divorce, I'd say follow your gut feeling. Most likely the answer is yes, but let's read more. Hi there, and welcome to Ask Ilona. I'm Ilona Antonyan. I'm sitting down to help answer your questions about your emotional health, surrounding relationships, as well as any legal questions you've got about your breakups. You wrote in with your questions, and I'm going to help you sort everything out and hopefully help you see some things more clearly. We switched up the format for this week, so instead of answering just one question today, I'm going to answer two. We had two women write into the show. Both are struggling with the ramifications of divorce. One is just starting the proceeding, and the other is post divorce, dealing with continued custody disagreements. Now, let's get into the first one. All right, guys, we're going to start with the first submission from Anti Fishing Wife. Dear Ilona, my ex husband won't stop emailing my employer. What can I do? The first thought that comes to my mind is get a restraining order. That's harassment. We'll get to it in greater detail later. I work for the same school district and at the same school my child attends. For the past year, on and off, my ex husband and his attorney have been emailing everyone from my principal to superintendent and school board demanding that he be allowed to check out our child from school early so they can go fishing. Okay, a little bit excessive here. If he's going overboard like that, I would get a restraining order and not deal with it. I know it's embarrassing, and considering he's taking it all the way to school board, I'm sure people think he's a little nutty, but regardless, you have to deal with it. And what do you do about it to stop it? So, our court order states that his parenting time begins at school dismissal. It also has a provision allowing early checkout for travel, but he rarely provides the required travel notice. If he rarely provides you the required travel notice, your remedy for any violation of a court order, as long as it's specific, is to file for contempt, which is a semi-criminal action for first violation. If he's found guilty, the court can either send him to do community service or a fine. The second time he's found guilty of contempt, then he'll have to do time in jail or some other remedy the court may order in addition to fine and or public service. The court may suspend time he will serve, but jail time is mandatory under the code. Next, you say that because he repeatedly attempted to check out our child early without authorization, at my principal's recommendation, I removed his early checkout privileges. Well, that's in compliance with your court order because the family court order overrides the privileges you voluntarily gave him through school. So that's okay. He's still able to pick up our child at regular dismissal in the car rider line. Okay. One incident escalated to the point that the school resource officer was called. His emails to district leadership have created problems for me professionally. If that's the case, again, that will be actionable through a restraining order, depending on the recency and gravity of his actions. Because it is disturbing your peace. He's disturbing your peace on multiple levels now. So you have that element satisfied, and that's sufficient to get a restraining order. I have primary physical custody, and he has parenting time every Thursday overnight and every other weekend. I also have the final decision-making authority for education, medical care, religion, and extracurricular activities. If you have that final authority, that tells me you've been to court and the court has already decided who is best to make those decisions and has given you that authority because you've provided examples of when he was unreasonable and difficult to work with. So you've gotten that authority, unless he just agreed to that voluntarily, which I doubt. So if you already have that final decision-making authority, that gives you credibility in pursuing other relief that will make your life easier, including restricting his continued violations of the existing order and or getting a restraining order for yourself. This week, my principal called my classroom and asked me to provide a digital copy of our parenting plan because of my ex's latest email to the district leadership. He's harassing them, probably threatening them. I mean, if it's to the point where it's harassing the school district, they could also seek a restraining order against him that would protect you since you're an employee at the school. Now they want a parenting plan. You have a court order. You should provide them a court order, and that's it. If someone has not prepared a court order, get court minutes copied from the court file. All you do is go to the courthouse business office, give them your case number, pull all court minutes, and if no one prepared a formal court order, get the court minutes and provide those to them. What legal options, if any, are available to stop a parent from repeatedly contacting my employer in connection with custody disputes? A restraining order. And a specific order that you can obtain without seeking a restraining order to prevent him from contacting your school or your employer or superintendent on specific issues. If you have copies of the emails he sent the school district, that would be great because you could identify what is the issue he's raising repeatedly and then get a specific order from family court. If you do not want to get a restraining order, get a request for order filed asking that father be prevented from contacting the school district or my employer regarding any custody disputes or pickup issues or whatever else it may be, and that the court should be provided a copy of the court order by which the party shall abide, and that's it. Something like that. It will be more of an admonishment. What will really have an effect is filing a restraining order or a contempt action against them. So he takes it seriously because he's going overboard here from what I can tell. And it sounds like you've been really patient. I wouldn't tolerate it that long if I was in your shoes. Has anyone dealt with a court viewing this as a harassment or interference with my employment? Absolutely, it is. My attorney has advised documenting everything and waiting unless he files another action. Well, your attorney may have more information than I have. Perhaps your documents and emails are stale, although you mentioned that just last week you were asked to provide a copy of the order. If you prepare a strong chronology and obtain copies of all the correspondence that he sent to you that appears to be harassing in any way, disturbs your peace to the point where a reasonable person will be bothered by this, and with what I'm reading here in summary, I think any reasonable person will be bothered by this. So you may have sufficient information now without waiting for him to take the action. Why should he be first to attack when you're being harassed? Like, protect yourself at all times, really. Like, stand up for yourself and put him in his place. So he doesn't feel like he's free to do whatever. Even if he chooses to go and file something in court when he wants, he can do that. You can do that yourself to stop him. Next, but I'm wondering whether there are other remedies I should be considering. I think so. To give you best advice, it would be important for an attorney to get copies of his communications with the school. If you're using any sort of communication tool that's court ordered, such as Talking Parents or Family Wizard or text messages, download them into PDF, bring them, highlight the ones you think are important, that tell the story, that bother you, so you can direct the attorney's attention in evaluating what's going to be reviewed by the judge and how bad does it look for him to give you advice. The attorney will analyze a chronology and assess whether current events are sufficient in combination with the past history of what he has done and said to seek a restraining order, or perhaps other remedy, file a contempt. So bring a copy of your current court order. If you don't have a court order, bring copies of the court minutes identifying what the past orders are that are operative at this point, and your communications and any communications he sent to the school that you can get your hands on, or to the school district or the board of the superintendent or whoever it may be. Bring all that and you'll probably be able to proceed with the restraining order sooner than later. Actually, the sooner you do it, the better, because the older your evidence gets, the weaker your case for restraining order becomes. Signed, anti-fishing wife. I think it's time for you to go fishing, either for another attorney or a restraining order. Our next submission is from Confused and Frustrated in Colorado. Pardon my Russian accent here. Next, Dear Lona, is my husband trying to screw me in a divorce? If you're wondering whether he's trying to screw you in a divorce, I'd say follow your gut feeling. Most likely the answer is yes, but let's read more. My husband and I recently separated after 10 years of marriage. So, ring, 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 10 years of marriage. That means in California, at least, that whoever is the higher earner, is on the hook to pay support indefinitely, depending on your life circumstances, such as your relative age, your relative health, your relative ability to earn income, sacrifices made during the marriage to raise children, and they go on and on. Let's get back to your question. We're talking about mediation and how to separate assets. He has said he doesn't want me to get an attorney. Okay, red flag right here. He should want you to get an attorney so you're fully advised of your rights so you can make an informed decision. If he tells you straight up he does not want you to get an attorney, he's probably playing it off by like, let's save money. Let's not talk to attorneys. Let's just make a deal. I'll be fair to you. Let's just whatever. But you're not going to know what you don't know unless you have a lawyer advising you. That includes what are your rights, legal rights. Once you know what your legal rights are, you're free to give up whatever you are willing to give up and reach a deal to keep peace or resolve things quickly. But it's important to understand your rights so you don't go into it blindly, just agreeing to whatever he proposes and not knowing what assets may be out there that he may not be disclosing. I'd like to make a note about how mediation works before we go into this. So mediation is great, but as long as you understand your rights and have all information, and you can ask questions of someone who understands the laws before signing a final document that will impact your future financial situation. There are situations when people reach an agreement and take another person's word for what's out there, and they have the mediator prepare disclosures for both of them. So one party prepares it, honestly, they'll half-ass it, and then the mediator will copy it over for you, so your disclosures will match the other person's disclosure. You're the outspouse. You may not know what is the entire estate about. What are the assets? Does he have secret accounts? Does he have secret investments he hasn't disclosed? So if you're simply relying on going to mediation and doing things peacefully, the mediator is not going to give you legal advice. The mediator will say, how does this sound? Great. Okay. Do you agree? Okay. Yeah. Did you disclose everything because you signed under penalty of perjury that these are all your assets? He'll say, yes. You have 1 year from the time that an agreement is signed in mediation that is turned into a judgment to potentially set it aside based on mistake of fact or mistake of law. And unless you consult with an attorney, unless you discover something that will cause you to realize you made a legal mistake or a factual mistake, chances are that 1 year will pass and it'll be too late for you to do anything about it. However, there is a statute in California that is called omitted asset statute. If he doesn't disclose something, or if an asset is not specifically written in a judgment or agreement and divided, then you could return to court in the future if you find out something exists that was undisclosed to ask the court to divide it. It's called an omitted asset motion or an unadjudicated asset. A lot, however, depends on how the agreement is written. That's why in mediation it's important for each party to have an attorney so your attorney can give you advice and be specific about protecting your interests in case there is an omitted or an unadjudicated asset down the road. Because if there's a general statement that everybody keeps what they have in their possession and that you guys are giving up your rights to discover information from each other, you're giving up your rights to do evaluations of potential businesses or appraisals of real estate, you're giving up those rights, especially after 10 years of marriage. All right, so let's go on with the rest of it. So he said he doesn't want me to get an attorney. You heard my opinions on that one. He's asking to go to mediation, stating it will save money. Okay, that's exactly what I thought he was going to say. I'm aware mediation is cheaper. However, I'm out of my depths with these things, and my husband is making me feel uneasy. All right, you gotta do something about this. You gotta get a lawyer and don't listen to him. If you're feeling uneasy, he's putting pressure on you. He wants things done his way. He wants to control how things go in mediation. He's going to pay for mediation. Now, the mediators are not going to be impacted by who pays the bill, but you can tell he's trying to drive this his way. And you're going to be passive participant in accepting his proposal. And what you're going to hear when you go to mediation is, well, you guys can compromise or you can get lawyers and it can get expensive. But it can get expensive the other way as well, because you can miss out on assets that could be in your bank account to give you financial security going forward if you don't follow your gut. He keeps telling me that he wants things fair. That's good. And reiterating how he won't fight over splitting home equity 50-50. All right, that's great. But is there anything more other than the home? Because if all we have is a home, that's easy. We have home and you have potential spousal support. I don't see any mention of children yet here. So that would be simple to go to mediation and they write up an agreement. You just have to get a consultation with the lawyer, bring copies of your tax returns, his pay stubs, your pay stubs, if you have any W-2s, business tax returns, so they can calculate the amount of spousal support you may be entitled to. However, he has started selling off items purchased from marital funds and putting the money in a separate bank account. All right, that it's important to file for divorce as soon as possible, because the moment you file for divorce and he's served with a summons and petition, he cannot do that without your consent. It will be violation of automatic temporary restraining orders that go into effect. He would have to seek your permission to sell something. I would keep track of things that he's selling. I would tell him in writing, do not sell anything, or if you do sell something, you have to give me an opportunity to agree to the price and whether I agree to sell it. But ultimately, anything he sold without your consent, any funds that have been deposited to his separate account in his name alone, you're entitled to half of it because it is a community asset he sold. He can try to move money around, but this is a bad sign that he's doing that. He's somehow buying time here and pretending to be fair, but doing this without your consent is not fair already. So I would absolutely lawyer up. And then go to mediation. He also wants to keep his full 401k that was almost entirely built during our marriage. Well, if it was almost entirely built during your marriage, then it will be 50-50 as well, in addition to the equity in the house, if the house was purchased during the marriage. I don't know whether he contributed any money he had prior to marrying you towards down payment and purchase of the house, or whether you did that. If so, then each of you gets a dollar for dollar reimbursement of the amount you put towards down payment or any remodeling expenses during the marriage to gather those receipts. But for 401k, he wants it unless you agree to give him 100% of it, which you don't have to. You're entitled to 50% of it. And it is his burden to prove what he had in the 401k account at the time of marriage to you. And also it is his burden to show whether any of that money was withdrawn during the marriage. And maybe he used it to buy a house. Who knows what he did with it. But 401k is normally divided through a qualified domestic relations order. You guys will each pay like $750 or maybe $1,000 each to hire a joint expert. It's called a quadro prepare, QDRO prepare. You can agree to hire one right away. If you go to mediation, they'll say, okay, let's just hire a quadro prepare. And you can give them all the documents about the 401k, and they're going to look at your date of marriage, date of separation. They'll give husband an opportunity to provide any evidence of any rollovers he had into that 401k, and they'll tell you what you're entitled to, what he's entitled to. And then that amount, 50% of what's accumulated during a marriage, will be transferred under your Social Security number without any tax consequences. So you can later use that 401k plan to borrow against if you need a loan without cashing it out, or cashing it out whenever you'd like. If you do it after 59 and a half, there's no penalty. If you do it prior to 59 and a half years old, then there's 10% tax penalty. All right, back to the rest of your inquiry. We made a decision to pay more into that fund because of the match his employer offers. Because it is in his name, he says he should keep it all. False. Already told you what to do. You're entitled to 50% of it. There's nothing you can do through court or legally to keep 100% of it unless you agree to it. And I wouldn't see a reason why you would. He also earns considerably more than me. That means he would be paying you spousal support. He would be fine walking out with just his paycheck. Not that I'm suggesting that! Exclamation mark. He would not struggle to buy another house and pay a mortgage. I myself would be living paycheck to paycheck, even if I used all of my share of the equity as a down payment on a new place. While you are entitled to spousal support, he's going to try to lowball you. I think you need to understand, based on your actual financial documents, what you're entitled to, what's your best case and worst case scenario if the two of you were litigating this in court. That way, when you go to mediation, you can agree to a number somewhere in between. When it comes to permanent spouse support, you guys can negotiate that he pays you a lump sum to buy you out. He may be interested in that because there's an indefinite right to spouse support because you're over 10-year mark. Or you can agree to modifiable spouse support, meaning that you agree to X amount now, and then he can go to court, or you guys agree to gradually reduce it over time for a period of time. Alternatively, you can leave it open-ended. This is what he pays you now, and anybody can go to future and change it later. But it all depends on your marital standard of living. When you both split up, now you have two households to support with same income you had for one household before. One of the factors the court looks at is your marital standard of living. So during the divorce proceeding or even a mediation, you'll be preparing forms called income and expense declaration. You can identify all sources of income you have, all your expenses, to assess what were you spending each month on average after taxes on your living expenses, and how can you both continue doing that in separate households with the income available for support. That's what attorneys can help you with, is assess what is your marital standard of living and also protect you in writing it up in a judgment or an agreement in mediation or through attorneys. Label it in a judgment, and then it's important to have in the order, if you're the recipient of support, whether the amount you agreed to meets the marital standard of living or does not. Because if it does not, when he tries to reduce your support in the future, you can argue now he makes more money potentially. Now you make less money or the same amount, and his support amount should remain at the same level as before because initially it never met the marital standard of living that you were accustomed to. These are all legal issues that we consider from different perspectives when you come for a consultation, but things you want to know without getting legal advice and guidance during the mediation process, which you should absolutely go to mediation. It's a good idea, but you need to have someone who's going to watch out for you. When I had a consultation with an attorney, they told me to consider alimony. Yes, it's called spouse support. Alimony is another word. In California, we say spouse support, but you're in Colorado, so they probably use that. I'm not looking to make life difficult for him, but it's something I may genuinely need. You probably will. And this is your only opportunity to negotiate for yourself so you can be comfortable in the future once this long-term relationship ends rather than struggle. Essentially, I will get half the equity from the house and half the savings in our checking account and my car. He gets the rest. Equity, savings, 401k, stocks, and his car. That is absolutely inequitable. That is not even fair. That's not what the law is. Makes no sense why you would just say okay to that. You should go for 50% of everything you're entitled to. He told you that he wants things fair. Well, that's a fair thing to do. Everything is 50-50, not just home equity. The only thing that I'm wondering about is whether he's agreeing to give you 50% in the home because maybe he bought it before the marriage. If that's the case, then perhaps he's offsetting everything else and equalizing it. But if not, if you bought the home during the marriage, then it would not be fair. Next, it doesn't feel right to me. Would mediation address this? No. Or is mediation just to draw papers based on agreement we make with each other? Yes, majority of mediations are like that. Recently, we had a guest on our Glamorous Grind podcast. She's a mediator, Julie Cobalt. And I asked her that specific question about different types of mediations. Because in my experience, and as she confirmed, there are those that just ask you what you guys agreed to and write it up. And there are those such as retired judges who've been on the bench, who've litigated things, and they'll tell each party, here's what's going to happen in court if you go to court. So this is what you need to do. If I would go to see a mediator, I wouldn't go to someone who never litigated family law cases. I wouldn't go to someone who just draws up papers. I would look for a retired family law judge, because there are going to be red flags and they're going to follow the guidelines to ensure that things are done fairly, although they are neutral. The episode about mediation on Glamorous Grind podcast comes out next week. So if you want to learn more about mediation, different types, and what happens, watch it next week. Thank you for your help. Well, thank you for writing in and letting us participate in your life story. And hopefully this has been helpful to give you guidance on how to best protect yourself. Should you stay or should you go? Can your ex legally do that? What should you expect before, during, and after divorce? If you have any questions like that, write into our show and we'll talk about it. You can send them to podcast@antonyanmiranda.com. Thank you for tuning in and being vulnerable, and I'll see you next time on Ask Ilona.